Greetings, people, and welcome to Good Evening Nigeria. The Federal High Court sitting at the FCT here in Abuja earlier this week, on Tuesday to be precise, threw away the suit that was instituted by 5 residents of the Federal Capital Territory here in Abuja, asking the court to stop the inauguration of Bola Tinubu for reasons that he did not score 25% of vote cast in the FCT. Now, the Federal High Court did not just throw away that suit. They equally punished the lawyer, I think Nwachuku by name, for bringing such suits, which they called frivolous, to the Federal High Court. Now, these were the reasons the suit was thrown away. First, they claimed that the Federal High Court does not have the jurisdiction to entertain such case, as all cases pertaining to election petition matters were squarely rested at the shoulder of the election petition tribunal at the Court of Appeal. Secondly, they equally claim that these 5 citizens do not have the legal rights to institute the case in the first place. And as a matter of fact, the election petition tribunal is equally entertaining the same case, and there was no reason for bringing the case to the Federal High Court that do not even have the jurisdiction to entertain that case rather. And having said that, they decided to punish the lawyer for reasons they claim that after examining the case, they discovered that the case was that of the voice of Esau and the hand of Jacob. I know that those who are Christians will be able to relate this very well, the voice of Esau and the hands of Jacob. What that simply means is that the case was clearly a case of the lawyer, that the lawyer only pretended that he was a counsel to these 5 citizens of FCT. He only hired these 5 citizens of FCT to claim that they own the case and hired him. But on the other hand, the case actually belonged to the lawyer. And so they said the case was frivolous and fined the lawyer 20 million naira. 20 million naira to be paid to the Attorney General of the Federation and the Chief Justice of Nigeria, because these people were equally added as parties to the suit. And so that was how the case ended. And they equally claimed, said they were going to report the lawyer to the NBA Disciplinary Council that would discipline the lawyer for bringing a frivolous case to the Federal High Court, knowing fully well that the Federal High Court does not have the jurisdiction to entertain the case. I think that was how the whole issue ended, and we'll be looking up to the Court of Appeal as far as this case is concerned, whether or not it is mandatory for a presidential candidate to score 25% in the FCT. I think the Court of Appeal will do justice to that. I'll keep updating you on these issues. My name is Richard Ago. Bye.